Hi everyone, this is a video where we're going to have a look at public order offences. We're going to primarily look at the Public Order Act, but we will touch on breach of the peace and some other laws surrounding public order situations. So, why are we looking at public order from the perspective of human rights? So, a lot of the public order laws that we will have a look at are all to do with protest. So, Article 11 of the European Convention on Human Rights protects an individual's right to protest by holding meetings, demonstrations, marches, as you can see in these photos too. This is a qualified right, which means, as I've said before, it can be interfered with by the state and its agencies, so the police, for example, but only if the interference is prescribed by law, necessary in a democratic society, and meets a legitimate aim. So, what restrictions are put in place need to be proportionate. We'll look at the margin of appreciation as well. So, freedom of assembly is very important as it's used as a vessel for freedom of expression. You can see here these people aren't just assembled; they've also got signs. They're shouting, they are chanting, they're doing whatever they need to do to get their feelings across, their opinions across, their beliefs across. So they do go hand in hand, freedom of assembly and freedom of expression. This right to assemble is inherently important in a democratic society because it gives individuals the means to bring about attention to key societal issues, so things like the climate crisis. So Extinction Rebellion here, they were protesting to encourage the government to actually declare a climate crisis in order for us to be able to change our ways and to protect the planet more. To influence public discourse or public opinion, public conversations, such as Black Lives Matter. We started thinking about police brutality, both over the pond in America and also what was happening in our streets in the UK too, and to shape political processes. So, Kill the Bill, as I said before, Kill the Bill is ironically a protest to try and discourage Parliament from passing a law that reduces the right to protest or puts limitations on the right to protest, which we will have a look at in a bit more detail at the end. So, even though the freedom to assemble is inherently important, there is some control needed for it to be meaningful. It's that balance though. If there's too much control and order, there'd be dire consequences. There wouldn't be any healthy debate. There would be less criticism of the state. We are very lucky in the UK that we are able to criticise the state without any repercussions. And people would lack imagination and spirit. We would all be kind of carbon copies of each other. We wouldn't have that kind of oomph about us to want to go out and change things. So we do need to be able to meet, to protest, to express our opinions. However, if there weren't any restrictions at all, it may lead to lawlessness and disorder. Similarly, if there was very, very strict repression, especially now as we live in a very liberal society, if all of a sudden the Prime Minister would say, you are no longer allowed to protest, you're no longer allowed to X, Y, and Z, then we would probably go out and protest that. So a balance does need to be struck. That takes me on to this next point here. Eliot and Thomas are very good, two very good authors to quote. They wrote The English Legal System, a book that you should kind of pick up and have a read for your A-levels. Notes that a balance falls to be struck between the rights of individuals and general public concerns. So this means that those people who wish to shout, who wish to protest, who wish to picket, sit in, argue for what they believe in, should be able to do so. However, they should not be able to do that at the expense of other people who wish to carry on their daily lives. So if I go back to the Extinction Rebellion here, a lot of people agreed with what they were protesting for. They agreed with the fact that we do need to change our ways and we do need to protect our environment. However, they didn't necessarily agree with blocking up the main arteries in and out of a city. It's also very important to note that Article 11 only allows peaceful protests. It doesn't allow violent protests. If it was a violent protest, it goes against your Article 11 right. You wouldn't be able to say the police interfered with my right if you were violently protesting. It's only if it's peaceful. Okay, so let's start with the restrictions then. I will split these up into restrictions on marches or processions and restrictions on meetings. So the first thing to note is Section 11 of the Public Order Act. This holds that the police must be given a 6 days notice in writing, which must specify the date, the time, proposed route and the organiser's name. This must go to the local police station where the march or procession is being held. This can only be done where it is reasonably practicable to do so. So that is something to kind of flag up if you did have a problem question where the march was very spontaneous, for example. However, failure to give this notice is an offence. Therefore, under Section 24, which makes all offences arrestable, the police can arrest for a failure to fulfil this notice requirement. Section 12 then, this is where we start looking at the conditions. This gives the senior police officer, either the senior police officer at the scene or the chief of police if it's pre-planned, to give directions imposing whatever conditions they appear necessary to him to prevent serious disorder, serious damage to property, serious disruption to the life of the community, or intimidation. So these 4 things we've got highlighted here are what we call the 4 triggers. Okay, I'll refer to these as the 4 triggers in future. So these conditions that the senior police officer can do are not prescribed in the Act. There's not a list of things they can and can't do, but they must only do what appears necessary. So this looks at proportionality. Say, for example, there's a route plan that would go through the centre of a very busy town at rush hour. It might be that they decide to reroute it in order to prevent serious disruption. So that would be seen as to be proportionate for the aim. However, if they were to reroute it into the middle of a countryside where no one would see them protest, obviously that wouldn't be proportionate because it wouldn't allow people to actually protest what they needed to protest and make the impact that they wanted to make. So there are a balance here that it does have to be serious, and according to Reid, the 4 triggers should be interpreted strictly. Okay, they can't take a more liberal, more broad approach to this. They do have to be interpreted strictly, which does give more protection to the right to protest. Similarly, if I just go back up to Section 11 here, this notice requirement doesn't mean that the police give permission. It's nothing to do with permission. It's just to give notice in order to make sure that the plans are in place for it to happen in an appropriate manner, to make sure if the police are needed to ensure that it stays peaceful, that the police are available for the protest, etc. That any traffic is closed off, whatnot. So far, there seems to be a balance between restriction on marches with the right to protest. Section 13, however, is a slightly more extreme restriction. So Section 13 of the Public Order Act says that where the power to issue conditions under Section 12 is not sufficient to prevent serious public disorder, the chief officer can apply to the local council to have all marches banned for a maximum period of 3 months. There's one thing to note here, this does need the Home Secretary's permission for the ban. So on the one hand, this happens in very rare circumstances. They do need the Home Secretary's permission, and it's only where Section 12 conditions would not be sufficient. So it does happen in very rare circumstances. However, if it were to come about, if there was a Section 13 ban in order, because it bans all marches, it covers all of those, even those planned to be very peaceful in nature. So it's kind of a catch-all, which obviously restricts the right to peaceful protest for up to 3 months. So it can be seen as a bit extreme there. Okay, meetings then. Meetings or public assemblies. Section 16 of the Public Order Act defines a meeting or a public assembly, and it says it's an assembly of 2 or more persons in a public place which is wholly or partly open to the air. That's your definition for it. So, as with marches, there can be some conditions imposed on assemblies where they reasonably believe that the result of the assembly will be one of the 4 triggers. So just to go back to the 4 triggers, that would be serious disorder, serious damage, serious disruption, or intimidation. This intimidation is more of a political aim. These conditions are more limited than under Section 12 because they only include the maximum duration of the meeting, the maximum number of attendees, and the place in which it is held. And once again, we look at necessary, so that comes in with proportionality. Is it proportionate for the aim? So once again, it's that balance. It's only if the 4 triggers, one of the 4 triggers is met, and this one does have a limit on what conditions can be set. So there is a balance in place here. Section 14A, however, is slightly more draconian. This wasn't in the original Act. This was inserted into the Public Order Act at a later date. And this gives the power to the local authority, with the Home Secretary's consent, the power to prohibit the holding of all trespassorious assemblies for a specified period of not more than 4 days in the whole or part of the district, but not exceeding an area represented by a circle within a 5-mile radius of a specified centre. In other words, the local authority is able to ban assemblies that will be trespassory assemblies. You can have a look at the definition in section 14A. For up to 4 days in an area that they see fit. This again is quite an extreme power. It's quite draconian to stop assemblies in a certain period of time. However, it is safeguarded by the fact that they need the Home Secretary's consent, and it can only be within 4 days within a certain area. Okay, 4 days is not a huge amount of time. However, some people may disagree and say that it is too extreme to ban meetings. So that is just a very quick overview of public assemblies or meetings, whatever you want to call it. Some other things you need to note are the offences. I'm not going to go through all of them. There are a lot of offences in general for public order, so you do need to go back over any notes that I've given you online. So Section 1, Section 1 is riot. So this is 12 or more people threatening or using unlawful violence, acting together for a common purpose. Okay, so it does need to be a common purpose, and there needs to be 12 or more people. The conduct of the 12 must be such that it would cause a person of reasonable firmness to fear for their safety. Okay, it's that reasonable man idea again for this. Section 2 then is a slightly step down, so this needs 3 or more people, and they do not have to be acting for any common purpose, but it needs to be that a person of reasonable firmness would fear for their safety for this. They need to be using threatening or unlawful violence as well. Section 3 then is a fray. So a person commits a fray by using threatening or unlawful violence so that someone of reasonable firmness would fear for their safety. So once again, very similar to violent disorder, but this one needs no minimum number of people. So you've got 12 people for riot, common purpose. Violent disorder, 3 or more people, no common purpose. A fray, no minimum people, no common purpose, but using or threatening unlawful violence. Section 4 then is the fear or provocation of violence. This creates an offence of either threatening, abusing, or insulting words or behaviour towards other people. This includes distributing any writing, sign, or any visible representation which is threatening, insulting, or abusive. There is also the intention to provoke or cause immediate unlawful violence. So they're wanting to kind of start a bit of violence through their language that they're using, either on a writing, on a sign. If they've got a placard, for example, they could do that as long as they are intending to cause violence. Section 4A then, I'm going to do this with Section 5. So Section 5 and Section 4A is harassment, alarm, or distress. So Section 5 is the lower of the offence, and this covers harassment, alarm, or distress and disorderly behaviour taking place in the hearing or sight of a person likely to be caused harassment, alarm, or distress. So they do not have to have intention for a Section 5 offence. However, Section 4A is slightly more serious, and they do have to be intended to cause harassment, alarm, or distress. A case to note for this would be DPP and Orem, which holds that a police officer can also be a victim of this offence. So they can be caused harassment, alarm, or distress through a placard, for example. Okay, that was a very quick run through of the. So we're going to have a look at SOCPA now. So SOCPA is a Serious Organised Crime and Police Act. This is not something you'd necessarily need to know in a problem question, more so for an essay style question. So SOCPA restricted the right to demonstrate within an exclusion zone of up to 1 kilometre from any point in Parliament Square. So demonstrators had to apply to the Commissioner of the Met Police for an authorisation for the protest 6 days in advance, or if this was not reasonably practicable, no less than 24 hours in advance. So within this 1 kilometre of Parliament Square, there were a lot more kind of hoops to jump through if you wanted to protest. It's widely accepted that this was devised to end the 5-year protest of Brian Hoare opposite the Houses of Parliament. So Brian Hoare was a peaceful protester who was protesting the Iraq War. There's lots of articles online about him. You can read up on him. So this was to catch him out and to make sure that he wasn't able to protest outside of Parliament. This law did kind of seem a bit retrospective, in the sense that he was actually arrested under SOCPA and his site dismantled as well, even though SOCPA came after he was protesting. So this act was a huge interference with the right to assemble and freedom of expression. Just down here, the key sections are 132 to 138. So, for example, Maya Evans was the first person to be convicted under Section 132, and this was for reciting 97 names by the Cenotaph Memorial in Whitehall near Downing Street. Okay, I think she's only fined £100, but still, it's the principle behind it that she is being restricted in her right to assemble and her freedom of expression. A nice quote to include into your essay for this would be Lord Strathclyde, who once said, "Freedom does not die in one blow, it dies by inches in public legislation." That's something really important to kind of think about now, especially with the current situation with the Police Crime Courts and Sentencing Act that has just received royal assent. It's important to note, though, the Police Reform and Social Responsibility Act 2011 has now repealed and replaced sections 132 to 138. It's not as draconian, but there are still some elements of SOCPA in this act here. Okay, next thing we're going to have a look at is the breach of peace. So, under common law, the police have the power to arrest without a warrant if a breach of the peace has been committed, if there's reasonable belief that a breach of peace will be committed, or if they think it will be repeated. So what is a breach of the peace? In R and Howell, it was noted that a breach of the peace is wherever harm is actually done or is likely to be done to a person or in his presence or to his property, or a person is in fear of being so harmed through assault, an affray, a riot, unlawful assembly, or other disturbance. So the arrest powers through the common law breach of the peace was widely used during the 1984-85 miners' strike to prevent access to picket areas where they were protesting the closure of the mines. It's arguable that the power to arrest for a breach of the peace was technically abolished by SOCBA because under Section 24 of PACE now, all offences are arrestable. Okay? It used to be that there were only certain types of offences that were arrestable, but now it is that any offence is arrestable under Section 24 of PACE, as long as it meets the necessity factors which we looked at under police powers. So we did have a look at the cases of Laporte and Austin. So in Laporte, it was held that the actions of the police were not proportionate, whereas in Austin they were. Okay, so there's a difference of decisions held based on proportionality. It was held that the police can only interfere with qualified rights when it's prescribed by law for a legitimate aim and when it's necessary in a democratic society. In Laporte, it was not prescribed by law and it was not necessary because it went too far. It wasn't proportionate. Whereas in Austin, the use of the barriers was seen as proportionate. Okay, we're going to have a look at two quick laws now. We've got obstruction of the highway and obstruction of the police in their duty. So under 137 of the Highways Act 1980, it's an offence to willingly obstruct the free passage along the highway. So this includes a pavement as well as the road. If a police officer orders a speaker, a distributor, vendor, or audience to move along and they refuse to do so, they're likely to be arrested for obstruction of the highway or obstruction of a constable in the execution of their duty, which we'll have a look at in just a sec. A case you can use for this is Hurst and Agoo. And these are the questions they would ask. Was there an obstruction of the highway which included any occupation of part of a road, thus interfering with people having the use of the whole road? So unless de minimis there is, unless it's like a tiny part, imagine if you're on private land and your toes are on the road, you're not really blocking anything there. Was the obstruction willful in the sense of was it deliberate? And was the obstruction without lawful authority or excuse, which covered activities otherwise lawful in themselves, which might or might not have been reasonable depending on the circumstances? Okay, so if you are obviously committing a crime, if you are obstructing the road, things like that, without a lawful reason or lawful authority, then you could be arrested for obstruction of the highway. So obstruction of the police, very straightforward. Under Section 89 of the Police Act 1996, the police can arrest you if you are obstructing them from carrying out their duty. The courts have been willing to uphold a wide use of this offence, even where it restricts freedom of assembly. A case you can use for this is Duncan and Jones. In this, there was a speaker addressing a crowd from a box on the highway, and he was told to stop by the police because the police feared a breach of peace. The speaker was then arrested for refusing to do so, and the courts upheld the arrest. And so therefore she was convicted of obstructing the police in their duty. Really straightforward, that one. Okay, one final bit to note is the Police Crime Courts and Sentencing Act 2022. So this received royal assent in April, so it is a very, very, very new act. This is something that's been going back and forth throughout Parliament, ping-ponging across. And this is what the Kill the Bill protests have all been about. Unfortunately, this situation regarding protests does seem to be moving towards a more authoritarian regime, slightly more draconian, slightly more strict, because this new act has significantly widened police powers to put conditions on protests, including the ability to ban so-called noisy protests. So Amnesty International has described these new restrictions as a dark day for civil liberties in the UK. Many have argued that this new act will be in conflict with the values and liberties that have been the backbone of British democracy for many years. If you think about the way we have changed the law in the past, think of the suffragettes and the way they protest. Protest is a really important right for us in a democratic society. What I will try and do is tag a website for the government website up here for you to read a bit more about this act. Obviously, it's not the absolute end of the world. It doesn't ban protests completely, but it does add a few more conditions or restrictions on them and widens the police powers. Hopefully that was helpful, and I will see you next time for the next video.